Thank you so much for having me today. It's a pleasure to be able to speak to you from Portland, Oregon. Today, we are going to talk about the UN Convention on the Law of the Sea, UNCLOS, as it is referred to by its acronym, and in particular, kind of introduce it, give a sense of the breadth of the convention, and then take a look at a couple of cases relating to marine pollution to see really the shortcomings of the Law of the Sea Convention. So there we go. So just to give you a sense of some of the wild ocean facts, and these facts are more or less current, but they are similar to what governments were seeing at the time of the negotiation of UNCLOS during the 1980s. Right, so we can look at any number of fish stocks, whether they're big fish like tuna, or medium-sized fish like cod, or even much smaller species. And we see declines, not just declines, but significant declines for most of our commercially harvested species. In fact, fewer than 10% of commercially exploited fish stocks are exploited below what we call maximum sustainable yield, and a significant proportion of our fish stocks are exploited at highly unsustainable rates. Part of the fisheries problem is not just the impacts on target species, but also on non-target species that are caught as what we call bycatch, whether it's turtles or sharks, or you can see the bigger picture here. You see a few shrimp in there, but in any wild shrimp fishery, about 80% of the catch is bycatch. Right, so that's obviously a huge proportion of the catch. But we also have problems relating to pollution, of course. Here we see just a wave, literally a wave of oil pollution. Oil pollution comes from land sources, it comes from marine vessels, and here we see the result of the explosion of a well in the Gulf of Mexico here in the United States. It's not just about oil. I'm sure many of you have heard of the Great Pacific Garbage Patch, and just a massive area. Texas is our largest state in what we call the continental United States, and this garbage patch is bigger than the U.S. state, the United States state of Texas, right? But we also have other sources of land-based pollution, including wastewater in many parts of the world. Wastewater from houses is just pumped straight into the ocean or other water bodies that then go to the ocean. And in fact, this was true of my own city of Portland, Oregon, until about 10 years ago. One of our biggest challenges these days is climate change. It probably is our biggest challenge, and that is having major impacts on the marine environment as carbon dioxide levels increase and temperatures increase. As a result of those higher levels of carbon dioxide, we are finding oceans becoming more acidic, right? And that combination of acidification and temperature is leading to coral bleaching and other impacts on marine life. And then, as we will discuss a little bit later, in this lecture, we have not just from Fukushima, but from nuclear power plants throughout the world, radiation being discharged into the marine environment. Right? So we just have this huge array of problems in our oceans. Some of these problems have their origins in our early conception of the law as it applied to the sea. We had this notion of freedom of the seas, and that with that idea, all of our ocean's resources were considered common to all. You couldn't claim sovereignty over any particular area of the ocean. You couldn't try to say this fish catch is only for us. That doesn't mean that you could not go catch things. In fact, the rule allowed everybody, every nation, every fisher to fish as he or she wanted, as long as they did not create some kind of unreasonable detriment to other fishers. So this obviously led to declines in fish stocks, especially in the post-World War II period, when many countries had developed large vessels, including fishing vessels, and were now using those vessels to catch more and more fish. Ultimately, and there were other problems as well. What we considered to be the high seas during this era was anything beyond 3 miles from a nation's coastal territory. That meant the vast majority of the marine environment was considered beyond the jurisdiction of any state and subject to this idea of freedom of the seas. After World War II, various coastal states started claiming territorial seas of 5 miles, 6 miles, 12 miles, even for some 200 miles from their coast. We saw overfishing, we saw pollution, we saw many coastal states beginning to drill for oil and gas in the marine environment. And there were no rules for how to do that. So nations got together to create essentially what many call the Constitution for the Sea, the UN Convention on the Law of the Sea, or UNCLOS. It is extraordinarily comprehensive. It establishes rules for navigation, whether that's innocent passage that takes place within a coastal state's territorial sea, and we'll come to this in just a second. It creates various zones that for fishing, for regulating navigation, for undertaking a range of other activities, and it gives the coastal states more or less authority to regulate those activities depending on which zone we're in. We'll come to that in just a second. We won't concern ourselves with what we call the baseline rules for determining where the coastline exists for purposes of identifying those different jurisdictional zones. But the convention has many rules, often complex rules, for determining what actually constitutes the coastline for purposes of measuring or identifying these zones. And then, unlike other international conventions, UNCLOS creates compulsory dispute resolution provisions. If two states that have joined UNCLOS are in some kind of dispute, they can use these compulsory dispute resolution provisions to resolve the dispute. it is different from access to the International Court of Justice. States of the world are not required to recognize the jurisdiction of the International Court of Justice. It is only if they agree to do so that they can use the court to sue another state or to be sued by another state. And then very briefly, we see lots of different things that UNCLOS regulates: navigation, fishing, conservation, pollution, and enforcement for all those purposes. We're talking about a treaty that's about 200 pages long, making it one of the biggest, longest international treaties that we have. So I'm just going to go through the jurisdictional zones quickly because it's relevant for the questions that we see posed in our case studies. Right? And there's a little bit more in these slides than we need to know. So because this was created by one of my former students who was in the US Navy. So he created some things that are specific to the Navy, and I'm going to skip over those. But you will see submarines and jet fighters and things like that zip across your screen. So again, prior to UNCLOS, the territorial sea for a coastal state was out to 3 nautical miles. UNCLOS now says it's 12 nautical miles. So we're expanding the area where states have sovereignty. That means it's essentially that the territorial sea is equivalent to the state's terrestrial territory, the landmass, right? So they have, with some minor exceptions, particularly in relation to navigation, the ability to regulate for fisheries, for natural resources, for oil and gas development, any way they want within the territorial sea. They have sovereignty there. Out to 24 nautical miles is a zone we call the contiguous zone. It doesn't have any bearing on what we're talking about today. It has it has status relating to immigration purposes, addressing drug trafficking and a couple of other things. The exclusive economic zone for fisheries purposes is extremely important. Out to 200 nautical miles, states have sovereign rights, not sovereignty, but sovereign rights to regulate fisheries. And they can do so to the exclusion of other states. Other states can't say, we've been fishing in this area for a long time, and so you need to allow us to continue fishing. No, whether it's the United States or the Republic of Korea, coastal states can reject requests to fish in their exclusive economic zones. So here, just enjoy the battleship coming in. And we. And then I'll wait for the fighter jet to stop making its noise. But what this is showing us is that on the high seas, right, there's no jurisdiction by coastal states. So what we now call the high seas is what in the past where we applied the doctrine of the freedom of the seas, which really extended from the 3 nautical mile mark. So now it extends only at in most places of the world beyond that 200 nautical mile exclusive economic zone. and we'll come back to this. We should have time to briefly introduce the negotiations relating to biodiversity beyond national jurisdiction, but it is in this space we call the high seas that the BBNJ negotiations and treaty, as it's referred to by its acronym, applies. Okay. Oh, and then the continental shelf is also an important zone. It extends up to 200 nautical miles, although in some circumstances it can extend beyond that. And the continental shelf is important for oil and gas resources. It's on the continental shelf that our coastal states have sovereign rights, again, exclusive sovereign rights to exploit those non-living as well as living resources of the continental shelf. But the importance of the continental shelf is almost exclusively for oil and gas and other mineral resources. So as part of, when we describe the exclusive economic zone, again, where coastal states have sovereign rights to exploit the living and non-living resources of that area, it extends up to 200 nautical miles. But of course, in many places, including for the Republic of Korea, you run into the claims of other states. And so here you see in only a few places does the exclusive economic zone of Korea actually extend out to 200 nautical miles. Here you're running into the claims of Japan, here Russia and North Korea, and then obviously China, right? So Korea actually has a relatively small coastal exclusive economic zone compared to, say, the United States or France or other countries. The United States has long coastlines without other states with competing claims getting in the way. Same for France and Australia. Well, and then France and the United States both have islands that are part of their territory in the Pacific, and they can claim exclusive economic zones and territorial seas around those islands as well. This idea of the exclusive economic zone has been particularly important for many of our Pacific Island countries with tiny, tiny land masses, but massive exclusive economic zones. This image just gives you a sense of how those states, which otherwise don't have any resources, now have access and control over fish and other resources in their exclusive economic zone. And then this isn't relating so much to what's happening with Korea, but I know with your exclusive economic zone, there are competing claims to certain areas, both with Japan and China. And so there are some contested parts of your exclusive economic zone. But in the South China Sea, you can see lots of competing claims among the various island states and other states, and creating lots of tension. But this is all for natural resources, right? As well as to, in the case of China, to exert military and political influence. But largely, this is all about getting access to natural resources. Now, just turning briefly to the rules for innocent passage, and you have some of this text in your materials. One of the key, and this is relevant particularly for our case study concerning shipments of plutonium, coastal states wanted the ability to control navigation through their territorial seas. But they also recognized that countries like the United Kingdom and the United States had important military operations happening in the marine environment. We had cargo vessels going everywhere. And so many coastal states wanted to ensure that these vessels could move freely through territorial seas without being unduly hindered by the coastal states. So innocent passage, and you see this in your materials in Articles 18, 19, and 20, 21, and 24, right? Where there's this tension between giving coastal states that additional regulatory authority, but also the competing claims of freedom to navigate for military or commercial purposes. Right? And so we see from Article 19 that passage is not innocent when it's prejudicial to the peace, good order, or security of the coastal state. And then we have a list of things that are considered prejudicial. I just want to, most of the subparagraphs in Article 19 relate to military type stuff, the things that you consider to be prejudicial to the peace and security of a state. But for environmental purposes, we see that any act of fishing without permission is considered to be not innocent, and coastal states will have authority to enforce those fisheries laws. But you see, with respect to pollution, the pollution is only not innocent if it is willful and causes serious pollution contrary to the convention, right? So it's a difficult threshold to meet. I mean, well, it's not, so we need what we call in law a mental state. It's not that you polluted accidentally, it's that you intended to pollute, or that you should have known you were causing this kind of serious pollution, right? So that's what we mean by an act of willful and serious pollution. And then we, of course, have that threshold of serious pollution. We're going to allow a little pollution or some pollution. We only prohibit serious pollution for purposes of our concept of innocent passage. Right. And then Article 21 tells us what we mean, or what it is that we're going to allow the coastal state to do. And we see that they can take action to prevent infringement of fisheries law, preserve the environment, conserve living resources. But Article 24 then tells us that the coastal state cannot regulate in a way that hampers innocent passage, right? So yes, you can ensure that vessels are not fishing. Maybe you require fishing gear to be stowed so that fishers can't quickly deploy their fishing gear to fish, right? But simply because a fishing vessel is passing through your territorial sea, you can't prevent that fishing vessel from moving through your territorial sea just because it's a fishing vessel, right? And then well, so that's all I'm going to say about innocent passage right now, so that we can get to our case studies. But I just want to highlight this again. I know I said this before, but this tension between giving coastal states the authority to regulate and the competing desire to have vessels move freely, right? And this is a real challenge to coastal states for regulating pollution from marine vessels in particular. as you see from these provisions, it will be easier for coastal states to prevent illegal fishing. So then, moving to our case studies, right? And so these case studies kind of bring the provisions of UNCLOS to life. I note that these shipments of plutonium continue. Right? Japan, as well as other states, have nuclear power plants, and they need to do something with the radioactive waste. There are only a few places in the world where this waste can be reprocessed for reuse or to make it safe for disposal. And it turns out these places are in the United Kingdom and France and a few other places. So Japan has been sending its waste to now France. It's no longer being sent to the United Kingdom. When we go back to 1992, this is among the first shipments of nuclear waste, and environmental groups were very concerned that this was going to cause problems, marine pollution, right? We're sending plutonium, right? One of the most radioactive substances on Earth on a 20,000-mile voyage, right? And so they wanted to stop that. And they wanted Japan to figure out a way to deal with this plutonium within Japan so that we didn't have to risk pollution entering the environment. And so the facts you see in this case study are all real life facts. I didn't have to make anything up here, right? You see, this is just another one of the ships that is used to ship the plutonium from Japan back to Europe. In terms of how this is done, and this is relevant for answering the questions here, it's a serious endeavor. It's not as if Japan is just putting just a typical, at least in the United States, we just call it a 55-gallon drum filled with waste on these ships. You see, it's the waste is put in these flasks, and which are then put inside these massive containers, and then you see that we now have the Akatsuki Maru was kind of a refurbished vessel and wasn't specifically designed for shipments of plutonium, but now we have the ships that are used are specifically designed for shipping plutonium. And you see they all will have double hulls in case there's some kind of accident. We won't necessarily have any waste of any kind spilling into the marine environment. And then there's a special place where the waste is stored that is well inside the vessel and well away from the edges of the vessel, again, in case there's an accident. Now, there are several ways Japan can get that plutonium to France, right? What we know, so this information is not public, but what we seem to know is that most of the shipments are following this line, this blue line around Australia, and then around the tip of South Africa, and then heading north to France. And the question is whether UNCLOS says anything about these shipments. Right? Can South Africa, as presented in the case study, do anything to stop these shipments going through waters under its jurisdiction? And so the first question is, may South Africa prohibit the Akatsuki Maru from entering its exclusive economic zone? So again, that's that marine space from 12 nautical miles to 200 nautical miles from its coast. Now, here we look to the provisions of UNCLOS that follow the case studies, and we see, yes, there is an important but general obligation to protect and preserve the marine environment. We see that states must take best practicable means at their disposal and in accordance with their capabilities to prevent, reduce, and control pollution. And then in Article 194, paragraph 3, we see that states can take measures that deal with all sources of pollution, and states are to minimize to the fullest possible extent the release of toxic, harmful, or noxious substances into the marine environment. Do any of these provisions allow South Africa to prohibit this vessel from entering and transiting through its exclusive economic zone? The answer is no, right? We see in Article 194, paragraph 4, that in taking a coastal state, in taking measures to prevent, reduce, or control pollution, must refrain from unjustifiable interference with the activities carried out by states in the exercise of their rights pursuant to the convention. And those rights include, when we're in the exclusive economic zone, the freedom of navigation. What that's telling us, so the rules relating to innocent passage are different from rules relating to freedom of navigation. The rules relating to innocent passage give coastal states rights to regulate the navigation of vessels in the territorial sea and only the territorial sea. Those rules don't apply to the exclusive economic zone. In the exclusive economic zone, you are not allowed, really, there are some minor exceptions that don't apply here, to regulate the transit of a vessel that would prevent it from entering the exclusive economic zone, or really from traveling through the exclusive economic zone. Maybe if there's a particularly sensitive habitat, like a coral reef, you could require the vessel to use a sea lane to avoid that sensitive habitat. But you would not be able, as the coastal state, to prevent the ship from passage through your exclusive economic zone. Question number 2. May South Africa prohibit the Akatsuki Maru from entering its territorial sea? So now we are not talking about freedom of navigation. Now we're talking about innocent passage. South Africa has greater rights, but do those rights allow it to prevent passage? Most people say no, right? Is the vessel polluting? No, right? The plutonium is in those flasks stored on the vessel. And as long as they are stored on the vessel, they're not polluting, right? Article 24 of UNCLOS also says states shall not hamper innocent passage and shall not impose requirements that have the effect of denying or impairing innocent passage. So maybe we can confine the vessel to a sea lane, but it will be very difficult for a country to legally prohibit the movement of the vessel. Now, I have to pause here to say that a large number of coastal states, especially in the Caribbean, are prohibiting the passage of ships carrying ultra hazardous cargo like plutonium. No state has challenged those rules, and it may be that we're now creating a new kind of international law that's different from UNCLOS. There's a kind of law in international law that we call customary international law that doesn't require a treaty. It is based on the behavior of states acting consistently. And so if we get more coastal states creating these kinds of prohibitions, maybe we are creating a new international law, and that these provisions of UNCLOS are not applicable to these kinds of shipments of ultra hazardous wastes like plutonium. Now, can South Africa demand, so question number 3, can South Africa demand that Japan prepare and publish an environmental impact assessment? As you see from the materials, there are 2 different provisions relating to environmental studies, let's say. Article 204 refers to the monitoring of risks or effects of pollution. States shall endeavor as far as practicable to observe, measure, and evaluate the risks or effects of pollution of the marine environment. Right? So can we say there's a risk of pollution? Well, maybe, but we've never had any accident of plutonium into the marine environment from a vessel. So to the extent that we're trying to apply Article 204 of UNCLOS, Japan's study would be a pretty short one. no impacts, right? Now, of course, we may try to take that a step further and say, well, if there is a spill, what would the impacts be, right? And now, if I'm Japan, and I'm not saying this is the right argument, but if I'm the lawyer for Japan, I say, well, there's no risk. We've been doing this now for 30 years, and there's never been an accident of any kind, right? Can we get, so now turning to Article 206, can we get an environmental assessment undertaken prior to the ship leaving Japan and traveling to Europe? Article 206 says when states have reasonable grounds for believing that a planned activity may cause substantial pollution of or significant and harmful changes to the marine environment, then they shall assess the potential environmental impacts of that activity. So again, if I'm Japan, well, I would say, well, there's no reason to believe that there will be substantial pollution because, again, there's never been an accident. And if we turn back to the way our ships are designed, the design of the ship is intended to prevent any pollution, much less serious pollution, to the marine environment. So it's not looking so good right now if you're South Africa or any other coastal state seeking to get additional information from Japan about how much plutonium is on the vessel, what might the impacts be, because not all plutonium waste is the same. There will be other things mixed in with the plutonium, as we will discuss when we get to the Fukushima example. So the remaining questions: can we demand Japan conduct research or develop alternative techniques to the shipment of this waste? As we saw earlier, Article 194 directs states to use best practicable means to prevent, reduce, and control pollution of the environment. Again, if I'm taking the position of Japan, I would say we have done that by using these kinds of ships. Right? That is using the best practicable means to prevent, reduce, and control pollution. Since 1992, we haven't really seen a lot we haven't seen environmental groups contest these shipments. Partly it's because we don't know when they happen. Japan doesn't announce when they're going to send a shipment of plutonium. The risk of terrorism, especially these days, is far too great, although we do know which ships are capable of transporting plutonium. So my guess is it's not that difficult to find out when those ships are moving back and forth between France and Japan. But nonetheless, we're seeing a real absence of any advocacy to stop these shipments. Then lastly, question number 5, can we demand that Japan notify and consult nations along the shipment routes? And UNCLOS itself doesn't really help us, right? And that's kind of a theme to this first case study. UNCLOS isn't helping us at all, right? And there is in Article 198 a duty to notify any state of imminent danger that may happen to that state from an activity caused by this other state. But again, there's no imminent danger. Now, here, other international law can help us. There is an international duty to notify and consult with other nations when there is the potential for significant environmental harm. So again, we come back to that idea of, is there a threat of significant environmental harm? Maybe as part of just a freestanding duty to notify and consult, we're not able to get Japan to communicate with other coastal states because there is no threat of significant harm. But there's another international law obligation known as the duty to cooperate. And the International Court of Justice and other international tribunals have said that as part of the duty to cooperate, you must engage with relevant states. And the duty to cooperate exists in the absence of a threat of significant environmental harm. It's just part of being an international good actor. Nonetheless, Japan is, as far as I know, is not communicating with coastal states. And what we know is that it communicates with the United States and France as the repository for the destination for this waste, and maybe one or two other states, but that's it. It's definitely not communicating with all coastal states. Okay, let's. Oh, well, I should note also that so even if UNCLOS doesn't provide us with relevant rules, we do have other international organizations that have developed rules to govern the design of the ships and the safe transport of plutonium and other radioactive material. We have the International Atomic Energy Agency, as you see, with its mandatory regulations for the safe transport of radioactive material, and the International Maritime Organization also has rules, complementary rules for the safe transport of plutonium and high-level radioactive waste. Right. So this is always important to remember when we talk about anything dealing with the marine environment. UNCLOS is where we start our discussion, but there is almost always going to be another agreement or international organization that has additional rules to regulate that particular behavior or activity. Okay. And now I know, so that we're kind of coming up to date, and I think most of you are probably familiar with what Japan is planning here. I should note this wasn't an attempt to harass Japan with these case studies. They're just two really good case studies to study UNCLOS. So as you see from the case study itself and the materials, Japan has announced that it's going to release more than 1 million tons of treated wastewater from Fukushima. And it doesn't have a complete plan, but based on everything I've read, it appears that the waste will simply be released from some land source, that they won't take the waste on a ship and then dump it into the marine environment. And that's a key distinction, because UNCLOS has different rules relating for releases on land compared to releases or dumping from a vessel. We also have a lot of other law that applies to dumping from vessels under a treaty called the London Dumping Convention. Although to the extent this is low-level radioactive waste, the London Dumping Convention probably doesn't prohibit that. So again, what is it, just to give you a sense of how many barrels we're talking about here, there's more than 1,000 of these barrels filled with spent nuclear waste that Japan needs to do something with. And its plan is to release this waste into the marine environment over a 40-year period. Now, it hasn't finalized the plan, but this is the proposed plan or the draft plan as we know it. So what does UNCLOS tell us? Well, states have the obligation to protect and preserve the marine environment. Is Japan violating that obligation under Article 192 of UNCLOS by releasing this into the environment? We get into the question of, what does it mean to protect and preserve the marine environment? Surely it doesn't mean we can't release any pollutant into the marine environment. In fact, coastal states are doing it all the time. So a little pollution wouldn't violate Article 192, but but a lot might, depending on what the environmental impacts are, right? And here's where UNCLOS, like many other conventions, if you read the Convention on Biological Diversity, you see similar language, right? What does it mean to protect and preserve the marine environment? We don't have particular standards that say X parts per million of tritium can be released into the environment and not violate Article 192, right? We don't get that specific, right? And so this is the challenge of international law, trying to define what that might be. Is Japan, so turning to Article 194, is Japan using best practicable means at its disposal to prevent, reduce, and control pollution of the marine environment? Now there's debate, right? Lots of scientists say, no, Japan could find ways to store this on land safely. But even the International Atomic Energy Agency has said that it will be safe for Japan to release this wastewater into the marine environment. And in fact, the executive director of that agency has said countries are doing this all the time as part of their normal operations. Little bits of radioactive waste are constantly entering the marine environment. Now this is different, right? It's not part of normal operational activities of the Fukushima reactors. This is taking a lot of waste and putting it into the marine environment. What we know of Japan's proposal, however, is that it is trying to mimic normal operational procedures by doing this over a 40-year period. As a consequence, the government of Korea or another government could try to use Article 194 to say, that Japan has other means to dispose of this waste, but with an expert agency like the International Atomic Energy Agency saying this is going to be safe, that's going to be a difficult case to make. In addition, turning to Article 207, we see that the rules relating to pollution from land-based sources, and again, I'm assuming that Japan plans to release this waste from land, we see that these rules are very general. States shall adopt laws to prevent, reduce, and control pollution from land-based sources, taking into account internationally agreed rules and standards and practices, right? And we know that there are standard practices that other nuclear facilities are using for releasing nuclear wastewater into the marine environment. Consequently, so I was asked by some lawyers in China to provide some advice on whether or not the government of China might be able to prevent this discharge. And my initial reaction is that it will be very difficult to succeed. There are some provisions here that Korea or China or others could use, but it's a very difficult case to make. So there are some legal opinions that you can find online, and you will see that they are all quite vague. They all refer to Article 192 and Article 194, but don't say specifically how China or Korea could succeed on their claims. What they rely on to say that Japan, if it moves forward with this, just with these discharges, what they say to make the claim that Japan is acting illegally is that Japan has not performed an environmental impact assessment under Article 206, right? And now, so unlike in the shipments of plutonium case, I think now we have a much better case for saying that there is certainly reasonable grounds to believe that there will be substantial pollution. We don't know precisely what's in that wastewater. We know there will be tritium. There is likely to be other radioactive waste in there. So we need to know exactly what's in this wastewater. And as part of that, Japan needs to engage with other affected states like Korea, like China, who may have sensitive habitats to certain wastes in the wastewater, right? And so that's where we now might get some engagement of other states in Japan's plan to discharge this wastewater into the ocean.